Băieții, sunteți pregătiți? Luptați!
Cine a sărit pe Adriana?
Hai să vedem aici. Aoleu,
Costică a sărit pe
acolo.
Denisa. Denisa este la pământ.
Luptă!
Costică sare pe Dexar, pe Rechinul casează un pumn serios Rechinul de la una din fete. Adriana atacată de către Rechinul cu piciorul. Rechinul pumn în spatele capului.
Sus!
Eu zic că e de apreciat inima cu care el ne continuă.
Pauză!
Decizia aparține colțului albastru. Rechinu și Cos.
Vedem dacă au spațiu.
Fenomen, wow! Primul picior lansat de către Greuceanu. O armată de oameni a sărit acolo. Armată de oameni a sărit acolo pe Greuceanu. Se împartă în stânga și în dreapta, în toate direcțiile. Nu va fi ușor pentru cei doi să-i termine pe toți 10. Au pus ochii pe Denis din ce am văzut eu. Dar Greuceanu trimis la pământ, nu are voie să fie lovit la sol. A primit acea lovitură.
Denis Unger.
He ran across the cage. There we go. And on the single leg, trying to fight. Wicked one got it. He runs him down. And his man on the jab. They in. The ground and pound preventing. Oh, short shot. He's calling it out.
I had to hold myself back because I had too much power for a man his size. If I would push all my power into him, I would crush him. Yes, so I had a sparring session with him, just a joke one, a while ago before his big fight against Al.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct military and law enforcement alike all across the nation on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, etc. And so today we're going to answer the age-long question, does size matter? And I'm going to implore you that not only size, but training and really a lot of other factors really matter when we're talking about use of force. And so we're going to talk about the case law, and the case law specifically that we're going to kind of dive into today is going to be Connor v. Graham, 1989, because Connor v. Graham is a Supreme Court case precedence that really is one of a kind, and it's foundational in what we know now as the reasonableness standard, the reasonableness doctrine. And so let's get into it. In 1989, the Supreme Court case of Connor v. Graham established that the objective reasonableness standard should be used to determine if law enforcement used excessive force during an arrest or other seizure. This standard asks whether a reasonable officer in the same situation would use the same amount of force. Now, let me just caveat this with, what is the question that we talk about in my trainings, and a lot of my trainings especially, what is a reasonable officer? And the truth of the matter is, no one really knows. If you're a trainer, if you're an instructor, if you could really just give me, a case law that states this is what a reasonable officer is, this training, this experience, this is what reasonableness is. Because based upon all the case law I've looked at, based upon my years of study, my training experience, there's nothing that I can point to that says this is what a reasonable officer is. For example, is a reasonable officer a post-trained officer? Is it a DPSST-trained officer? Is it a Texas Department of Public Safety-trained officer? Is it an Oklahoma CLEAT trained and certified officer? Like, what training can we attest is reasonable, right? And so, given that we can't, and again, if you can answer this question and you can show me exactly where we can overlay exactly what a reasonable officer is, then we're kind of stuck in the gray here. And so my answer, and this is how I look at this, a reasonable officer is one that adheres to the standards and case law precedents that's already established therein. Okay, so I act as a reasonable officer when I act congruently within the standards that have already been placed by court case precedents. And I think that's important for us to understand, because as we start to go through this, and you start to go through all the various types of use of force, case law, and doctrines out there, you're going to see that having that knowledge is going to be very, very important. I mean, use of force is not something that we can just, quickly talk about in a 10-minute video, and all of a sudden you're an officer, or anybody for that matter, is ready to go out and really truly have a good grasp and understanding of this. I mean, if you look at, for example, the FLETC's use of force instructor course, I mean, that I believe that's a 20+ day course. And so there you can go into these various doctrines and situations and incidences, and you can break this down, and you could do that for years. And so again, we're not going to go into that much depth here, but I do want to give you a foundational understanding of this reasonableness standard, and part of that does have to do with these factors such as training, size, etc. So the next thing to look at that I think is really important that you have on the screen here is factors of force to consider. So the Connor v. Graham, or Graham v. Connor case, established a 3-pronged test to establish if excessive use of force was used. So these are the factors that have to be looked at. And a lot of officers, most officers I know and that I've talked to, they can't articulate with any real clarity what is excessive use of force. You say what is excessive use of force, and some people just think it's too much force. But really, what overlays that? What is the standard? What is the standard in which a judge and a jury is going to look at this? And so it is this 3-pronged test here. And so it's really important for officers to know, because when you use force, this is the test that you have to justify. Your justification for the use of force must be congruent with these standards. It must be congruent with these this 3-pronged test. So number 1, the severity of the crime. Is this crime a felony? Is it a misdemeanor? Are we just enforcing some kind of infraction? So the severity of the crime matters in regards to the use of force that is then applied. Okay. Number 2, the immediacy of the threat. And this kind of will go more into your force continuum, your triangle, your use of force triangle, intent means opportunity, things like that. But ultimately, what is the immediacy of that threat? So when you use force, whether you're a police officer or anybody else, understanding the immediacy of that threat and being able to articulate why that threat was one of immediacy is going to be extremely important in your case. Number 3, is the subject actively resisting arrest? Are they attempting to evade arrest by flight? These are all factors that are going to need to be looked at. The United States Supreme Court affirmed that the allowance must be made for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. Now, with that being said, I'm glad, let me just caveat this with, I'm glad that the Supreme Court has affirmed basically that officers have to make split-second decisions and we shouldn't armchair quarterback them. But let me just be very clear and precise, and I don't want to mince words. Society doesn't care, okay? For you officers out there, especially you younger officers out there, society doesn't care. They're going to armchair quarterback you till the cows come home. They don't care. And in the court of public opinion, that matters. It matters for the rest of your life. Regardless of what a court may say, if your use of force has been plugged all over Facebook, social media, the TikToks, the Twitters, the X's, the Snapchats, the YouTubes, wherever, Rumble, wherever the content of your incident may find itself, don't expect society to have the same vision as what a court's going to have. And don't expect just because there's no criminal charges brought against you, or you don't lose qualified immunity, don't expect there not to be consequences for the actions that you do on the road, for the actions you do while on duty in uniform. And so I think that's important. Again, we understand what the Supreme Court case is saying. We understand what the Supreme Court says. But you also have to realize that just because the Supreme Court says something and they make certain allowances for what they are going to view this scope through, don't expect society to care, because they don't. So, what are some other factors to consider? Here you can see on your screen, we have a few of them to look at, right? So the number of suspects versus officers, I think that's really important. You know, if you're a single officer responding to a scene of domestic and there's three suspects there, well, you're outnumbered. So your factors of use of force factors are going to be different as far as you being able to justify the use of force that you decide to do. You're going to have more you're going to have more articulation in the fact that there are more suspects than officers. And vice versa. If you go and there's one suspect and there's 20 officers, well, you know, same same thing. Your use of force, you can't justify this extremely high threshold of force when there's 20 of you guys there for one person, unless there's some real exigent circumstances. So again, these are factors that we need to be cognizant of and understanding of. The next one, size, age, and condition of the suspects versus officers, right? What does that mean? Well, if I'm responding to somebody who's a young man who is bigger than me, taller than me, stronger than me, right? His ability is going to be different than mine. You know, I'm older. I don't have the size that he has. So his condition, right? Does this guy look like he's a defensive end for, a professional football team, etc. Training is huge, right? If I'm going up against somebody that is a trained martial artist, right? And let's say they have name recognition, right? Well, somebody that is a professional fighter, especially if you've seen their fights, we've seen this all the time. Like, for example, John Jones got arrested for a DUI. There have been other fighters that have gotten in trouble for domestic violence, things like that. So that training and the training they have is going to be a factor when we're talking about our gram factors for use of force, things to think about. Intoxicant, impairment of a suspect, again, another thing to think about. I can say, let me just give you based upon my experiences, right? I have been in tussles with people that have been impaired or intoxicated by all sorts of things: methamphetamine, drugs, PCP, different various drugs, pills, PCP, alcohol. And there is a big difference between somebody who was sober and somebody, for example, who is completely yacked out of their mind on methamphetamine. Again, something to think about. A suspect's criminal history. You have your State v. Valentine case law there, but a suspect's criminal history, is this person flagged? Based upon my training experience, I've arrested this person, 5 times, and every time I've made contact with this person has tried to fight law enforcement, reference body cam footage, etc. So again, suspect's criminal history and their flight risks, for example, those are all going to be factors. Another one, especially big in modern day 2025, and as we push forward, is going to be psychiatric history. That's something to think about. Is this person having a mental break? Do they have a history of mental break? So there's so many, and this is not an exhausting list. There are so many different factors that that officers need to be thinking about and cognizant of, right? And these are all factors that you have to then take in, and then make split-second decisions. And again, while the courts may understand those split-second decisions, or they at least claim to understand those split-second conditions, again, don't expect society to care. Don't expect society to care. So again, these are things to think about. But the overarching message that I want to send to everybody is understand your case law. If you haven't read over Connor v. Graham, I highly encourage you to read it over. I highly encourage you to get a pen and paper and write down factors. I have factors here. What are some other factors that you may think of? Understand where use of force continuum starts. Understand all the different measures and means when it comes to use of force. And just know, again, size matters, training matters. There's a lot of factors that you have to make split-second decisions on, and we want to make sure you make the right ones. So I hope this video was helpful. Hopefully you learned something. Definitely go over and re-look at that Connor v. Graham 3-prong test. Again, super important. But again, I want you guys to be smarter. I want you guys to be more knowledgeable on what it is you have to do, especially when it comes to use of force situations. So I hope this was helpful for you guys. Tell me what you guys think in the comment section below. Tell me what are some other factors that I didn't list here that you consider to be Connor factors, Graham factors. Really interested in knowing what you have to say in the comment section below. If you like this video, please like, share, subscribe. And as always, guys, long live the Republic.